Privileged communications are designed to encourage socially desirable confidences. Examples of privileges involve communications between spouses, client and lawyer, patient and doctor, clergy and parishioner, or penitent and priest. At the crux, privilege is a shield against incrimination or self-incrimination. Typically, it is governed by the local laws of the forum state or the state where communication is required to be made if the claim of privilege is denied. Recognition by the states of privilege against self-incrimination is required by the 14th Amendment to the U.S. Constitution. On slide 3, I have made distinctions by grouping types of privy, privilege, and immunity. You will read them later at your own pace. Slide 4 is about the laws in general governing privileged communications. Slide 5 presents the exceptions to attorney-client privileges. Now, what happens when privilege rules conflict between jurisdictions? Imagine you are involved in a legal drama that crosses borders, like in international cases when documents are stored in different places. You might find yourself wondering which country's privilege rules apply to your confidential communication. And when privilege rules clash between different jurisdictions, courts or military tribunals have to decide which laws govern the situation. The first step is to identify if there is a conflict. In other words, whether a communication is protected as privileged in one country but not in another. Step 2. Once the conflict is recognized, the court or the tribunal will look to determine which jurisdiction should apply. They commonly use a test called the most significant connection or closest link. Practically, the courts examine whether privilege is seen as a substantive right or procedural rule. Some countries, such as the United Kingdom, the United States, treat privilege as a fundamental right, part of the substance of the case, while others see it as a procedural matter that depends on the rules of the court or arbitration seat. Civil law nations like France, Germany, Japan, Brazil, Indonesia, some in the Middle East, offer less broad or different legal professional privileges compared to common law countries like the US or the UK, especially for in-house lawyers or regarding settlement discussions, with fundamental rights being defined differently across legal systems. Countries with severe human rights violations, like North Korea, Eritrea, Syria, Afghanistan, severely restrict fundamental rights, including legal protections. Courts often try to balance these views to ensure fairness. They also consider the legitimate expectations of the parties, meaning what they reasonably believe about confidentiality or privilege protections. Sensibly, parties will try to invoke jurisdiction that favors their positions. Handling cross-border electronic communications adds complexity. Communications that take place in multiple countries at once can make it hard to decide which law applies. Documents stored in one country might relate to activities in another, and different countries have different rules. Some jurisdictions extend privilege to enhance counsel and some do not. A U.S. court might decide to apply a privilege law of the country where the communication was made if that country has a strong interest in protecting confidentiality. European courts follow the EU principles that extend privilege protections beyond just litigation affecting international tax and regulatory cases. Arbitration tribunals usually choose the law of the jurisdiction with the closest connection to the documents, balancing procedural fairness with the substantive rights of privilege. There can be little reason why the forum should exclude evidence that is not privileged under the color of the local law of the state, which has the most significant relationship with the communication made, even though this evidence is privileged under the forum's local law. Admitting such evidence cannot defeat the parties' expectations, as if they relied on any law at all, they would have relied on the local law of the state of the most significant relationship, the state with substantial interest in determining whether evidence of the communication should be privileged. If the state has not chosen to make certain evidence privileged, its interests obviously will not be infringed if evidence is admitted by the forum. Admission of evidence, if relevant, will usually be in the best interests of the forum state, since such admission will assist in arriving at the true facts to make a correct disposition of the case. In rare instances, the evidence will not be admitted when the admission of such is contrary to the public policy of the forum. This kind of situation may take place occasionally when the forum, which is not the state with most significant relationship with the communication, does have a substantial relationship to the parties and/or a transaction, and has a strong interest in the outcome of the case. In even rarer cases, the forum might consider a given privilege, let's say between the priest and penitent, as sacrosanct, and disallow introduction of such evidence even when the forum has no relationship to the transaction and the privilege was not recognized in the state of the most significant relationship. On slide 8, I lay down scenarios as to the states with the most significant relationship with the communication. Now let's jump back to slide 7, as I have to share my personal encumbrances over the ordeals I have been through. Let's start by determining the difference between privileged communication and ex parte communication. Ex parte communication involves one-sided contact with a presiding judge about the pending case without the other party's presence, which generally is prohibited for fairness, although there are exceptions to the rule. Whereas privileged communication refers to legally protected confidential communication that can't be disclosed even if relevant, again with some exceptions for waiver. The key difference is that ex parte is about fair legal procedure, propriety, and privilege is about protecting certain relationships, purpose. On slide 7, I have listed laws prohibiting ex parte communications. Exceptions that protect judges are in the quiz that runs from slides 9 to 13, with the answer key on slide 14. Now, what happened to me and why is my case about the judge's unlawful ex parte secrecy? Social climbing or attaining financial or reputational pinnacles are basic human instincts, but people manage it through two opposite ways. One is malign competition, stalking, defaming, disparaging, destroying the subject of envy, and the second is elevating oneself by self-improvement, earning more degrees, acquiring more skills, traveling, exploring various cultures, working hard, or being talented, creative, and kind. These two low-life lunatics, Marina Noble and Karine Martirosyan, belong to the former category, the destroyers. They are notoriously multi-faced, nefariously dishonest, sadistically harmful. They both indeed do not have a single redeeming quality. Never wrestle with a pig. You'll both get dirty and the pig likes it. George Bernard Shaw. All my tragedies and setbacks are due to these diabolical hooligans who have no respect for anybody, known for their bold lies, perjuries, signature forgeries, false accusations, defamation, impersonation, fortune hunting. They contact my schools, former classmates, co-workers, my church members, neighbors, even my LinkedIn doximity, academia, or Facebook connections to isolate me. All this is followed by their primitive play of victimhood by directly contacting the sitting judges of the ongoing cases with fake tears and fabricated drama, which constitutes an ex parte communication. That's why I decided that the short report of their violations would be relevant to this topic. Investing myself into this petty talk is self-humiliating beneath my dignity, But I have left with no alternative because these two monsters have officially cemented my name to theirs through the corrupt courts in an effort to equalize us by belittling me. Furthermore, I am in receipt of death threats after they learned that I am finally planning to write my memoir about their cruelties and crimes. To boot, my parental property, an invaluable memorial, is under a siege of their hunt through corrupt courts. So I rather have to hurry, and this is my life and identity protecting effort. Not only they scammed salacious emails from fake accounts opened under my name, but also flooded the internet with lengthy, crazy, redundant, defamatory posts about me, opening hate forums titled with my name in the sites with high search indices, where I could not even respond or clarify. They involve this officially diagnosed violent schizophrenic Araik Khachatryan from Rapan, who before moving to the US at age 40 did not even have any job record in his native country. I have never met or known this one. Joining them in the propaganda war against me, he messaged me on Facebook to come and slit my throat. The evidence is still available. They even went on publishing fake health advice blogs, even domains, with my name, intentionally spreading lunacy to make the world see me crazy. They were out of control right after they learned that I had graduated law school, earning one more degree, which they were thoroughly trying to prevent by contacting my schools. I obtained arrest warrants against them in panic psychosis. And also, after learning that I did graduate the law school, and after learning about the legal clinic that I had opened online, holding a master in jurisprudence degree, which I had deliberately chosen as I didn't want to be an attorney, they attacked me with 6 simultaneous legal actions full of willful lies, fabrications, smears, based on which you cannot miss that they are mentally sick. Acting pro se as my own attorney with no experience, because as a single mother I couldn't explain to my child that I was allocating his budget to waste on this trash. I fought all cases alone and escalated each of them to the Supreme Courts of each state. Meantime, I also recused all manifestly corrupt underhand judges who were installed there to architect the cases in a way that there will be no jury trials. And indeed, I was given no day, no room to present the ocean of evidence that I had, despite my timely written demands for jury trials. So these hit-and-run cowards evaded jury trials, and so the senile, next-day retiring judges without career anxiety were given in front of me, pre-written by them, orders to sign, who would sign in front of me without reading, to see at least that the judge's name was misspelled. With such orders, they wanted all properties I hold anywhere in the world. I'm not joking. My real property, inheritance, and intellectual property, the royalties from my books, which were meant for my son. They were rooting that their children would benefit from my book royalties even after my death, depriving that little money from my one and only child. And indeed, from 2019 to this day, my book royalties have decreased by 80%. I receive 1/5 of what I usually would receive over a decade prior to their attacks. And they started robbing me based on this lower court's order, even during my pending appeal. Prior to that, Marina Noble was meddling with my book royalties on Amazon in a role of a third-party seller, and after as an Amazon associate with direct access to my book interiors, and also by phishing fake transactions for what she was caught. So she was concerned that I'm enjoying a monopoly and she's out of it, but she wants to be part of it. They even installed a dishonest and obviously mentally sick stenographer who was their attorney's friend to rig or change the answers of my deposition, which was held in a disreputed private company, which I challenged and argued with my timely filed errata sheet. They were having court hearings by phone, by corded phone, not screen phone, where I had no way to see what evidence they claimed that the other party is presenting. It was so insulting and unconstitutional that I had to tell to the judge on the other end of the phone that I'm not sure whether I'm speaking to a judge or to the court's plumber. Or they were sending me court notices signed by a clerk who was dead 2 months before that notice was generated. So, court notices signed by a dead person. While in all cases they did not have any witness, in one, I mean a court by phone, they tried to present one and only witness, Terry Lundy, who appeared with his nickname, not even his full legal name, and who was the permanent employee of the law firm Sal.com that was representing them. So the only witness they have is an employee of the law firm that represents them. You will be able to connect the dots once you realize that you have to view these two women as mentally sick dangers. As for Marina Noble, former Mkhitaryan, raised in a very vulgar, violent family, while being herself when she's not playing different personalities, her every word, not every second word, is a curse, jail lexicon, because that's what normal means to her. And even after marrying to that William Noble, she was often using the P word in terms of male genitals, which was surprising why she was still sexually anxious when she was already married. And certainly one of her agendas behind those legal actions was to wed this Satan, very unpopular, repelling daughter, Asnif, to rob me and be able to mortgage a house for her, to make her a wanted woman. In their actions are apparent crimes, which I will explain in my upcoming memoir documentary. I have to, even though that would be a traumatic, unpleasant journey. And that explains why my process of writing that memoir is unusually slow, with endless procrastinations. I don't lie, as telling the truth is the best and energy-savvy strategy. If you lie, you have to keep lying to address questions about your previous lies, and that trapping chain is endless. Besides, why would I corrupt my soul and distort my conscience for others? I don't lie not because I respect others, but because I respect myself. Now, who are these women? As typical of old morons, they are deprived of self-criticism, irrationally revengeful. They are incapable of understanding the logic of reciprocation. They will ruin your livelihood just because you simply don't like them. Ugly inside and out, they are unfunny without a sense of humor. They have no clue in arts, architecture, music, literature, cuisine. They cannot sing or dance or play musical instruments. They certainly do not come from a pedigree. They have no class. They even lack dignity and manners to properly present a gift. They aren't even movie smart. Have them watch a 5-minute movie, even in their native language, and then ask them to summarize what it was about. They can't. And that explains why they are doubtful or dismissive of my authorship of scientific articles or books, as well as multi-genre books and songs, because as my smart son reflects, it is too much for them. Incapable of having or producing original ideas, they don't believe that others may actually have original or genuine ideas. They did not have the intelligent, doting parents that I had. They didn't have summer houses that my parents had. They didn't go to elite English proficiency schools that I went. They struggled to learn English at their ages 35 or 40, while I studied it from age 6. Unlike their primitive basic schools, in my English proficiency school, I studied Beowulf, Chaucer, Thackeray, Byron, Somerset Maugham, Cronin. From my very childhood, I already had and enjoyed the jet-set lifestyle with constant flights. These two women had put a foot aboard an airplane in their 30s. They didn't have a music education either, that I did, while my busy youth was full of concert travels. They tried to learn to drive a car when they were 45, 50, while I had a license since my age 18. Never destined to become medical doctors and being in public health field. They do not even know basic high school statistics, let alone biostatistics or epidemiology. In their native countries, they did not have a roof for living. Both were staying in free of charge undergraduate student dorms while no longer being students, or staying with their married relatives. Even their small dreams of being somebody's short-term mistress were not realized, as both were ugly and stupid. Both have never had a single romance in their lifetime. And I'm glad that they managed to marry in the US by means of blackmail, extortion, finding dummy, already discarded lost men from dating sites or Craigslist. The judges who backed them were as deplorable as they are, so it was a type of cluster bond in between. One of the judges was a former criminal defense attorney who had represented pedophiles for money. So don't hope for a sense of morality from this guy. And who corruptly normalized their perjury crimes such as faking cancer they did not have, or reporting fake phone numbers as if belonging to witnesses who did not even exist. I'll better report the entire legal journey in my memoir, as one presentation is not enough to cover their vicennial war against me. Now about my sponsor, which is me. I need, when I find free time, I need both intarsia and lace. Visit the Renal Decor website for orders or pre-orders. Now I will part, leaving you to study the slides at your own pace. So long.